Welcome, everyone, to this inaugural Asia Voices Perspectives on Tax Policy seminar. Thank you for joining us today. I think it's good afternoon and good morning to all of you joining in today. I'm Christopher Gee, Senior Research Fellow and Head of the Governance and Economy Department at the Institute of Policy Studies in Singapore, and I will be helping to manage today's seminar. After the OECD G20 agreement involving 137 jurisdictions just over a year ago on the global framework on base erosion and profit shifting, or BEPS 2.0, the Institute of Policy Studies convened a working group to consider the implications of this global framework on Asia. This led to a publication of an initial report by the working group in January this year, and we've now convened this seminar to continue the discussions on the issues for this region relating to BEPS. We understand that the Asian perspectives on BEPS have not been so much aired, perhaps as much as might be necessary, given the profound implications of the implementation of the framework on the various countries in the region, as well as all of the multinational enterprises that operate here. Today's seminar will focus on the global anti-base erosion model rules, Globe Pillar 2, and their impact on the role of tax incentives in economic development in Asia. We'll first have a keynote speech by Dr. Jay Rosengard, followed by 3 paper presentations and a discussion session involving all 3 presenters before we take a short break. We will then come back to have a panel discussion with 5 speakers who will then speak on today's topic from their own specific perspectives. Before we begin, may I please remind everyone to change their display names to reflect your full name and the organization you represent, if any, in brackets. This seminar is open for media coverage and is being recorded. Please use the Zoom Q&A function on the bottom bar of your screen to pose questions for the speakers or make comments, which we can then take up in the discussion sections of today's event. To kick this session off, may I now invite Dr. Jay Rosengard, lecturer in public policy at the Harvard Kennedy School, to give today's keynote address. Jay's dialing in from Boston, so it's an unearthly hour for him. He has 45 years of experience in public finance, public administration, and financial institutions development all around the world, but certainly in Asia, and we're so glad he can start today's discussions with some comments. He will then take some questions and respond to comments after his speech. Again, please post them on the Zoom Q&A function. Jay, over to you.
Thank you for the very gracious introduction. Good afternoon, Singapore, from a very late night Boston. It's both an honor and a pleasure to deliver the keynote address for this Institute of Policy Studies Research Seminar, Asia Voices, Perspectives on Tax Policy, for 2 reasons. The first, having served as visiting faculty at NUS for 1 year. This was at the predecessor to the Lee Kuan Yew School of Public Policy when it was on the main campus in the Faculty of Arts and Sciences. I feel that I'm still a member of the NUS extended family and only wish that I could be in Singapore in person. And the second reason is our topic, the OECD's Global Anti-Base Erosion Model Rules, also known as Globe Pillar 2, and their impact on the role of tax incentives in Asian economic development, is one of today's most complex and challenging global fiscal challenges. I'll try to keep my remarks to 15 to 20 minutes so I have an opportunity to engage in a dialogue with seminar participants. So I'd like to start by being clear on terminology so we're on the same page. So when I refer to Globe Pillar 2, I'm talking about the 15% global minimum tax on M&E groups, multinational enterprise groups, with consolidated financial accounting income in excess of 750 million euros in 2 of the previous 4 years. And it's comprised essentially of 3 top-up taxes. And please forgive me for the alphabet soup, but we're going to come back to these later. These are the IIR, the Income Inclusion Rule, top-up tax, the UTPR, Under Tax Payments Rule top-up tax, and the QDMTT, Qualifying Domestic Minimum top-up tax. And Globe Pillar 2 is intended to backstop Pillar 1, the new nexus and profit allocation rules, and it's to be implemented by the OECD G20 Inclusive Framework, created in 2016 and currently having 141 members representing more than 95% of global GDP. If we go back to the underlying policy rationale for Globe Pillar 2, it's based on two main principles. The first, countries have the right to impose or not to impose corporate income tax, and how. And second, countries have the right to tax foreign source income of residents. And the objective of Globe Pillar 2 is to address the current race to the bottom to attract FDI, foreign direct investment, and ensure that MNEs pay a fair share of tax wherever they operate and generate profits in today's digitalized and globalized world economy. And Globe Pillar 2 has tremendous potential to be a real game changer in global taxation if it is implemented successfully. And this is truly a remarkable achievement in international tax cooperation to improve tax efficiency and tax equity. A common minimum tax rate and common tax base would have been unthinkable a decade ago, and this is a huge boost for multilateralism. And successful implementation could also have significant impact on the use of tax incentives to attract FDI, which I will return to momentarily, as this is the main theme of today's research seminar. But first, it's important to note that policies are only aspirational unless they're well implemented. And I believe that most tax policy is actually made during policy implementation, which is why my Harvard Kennedy School Executive Education program on taxation is called Comparative Tax Policy and Administration, or COMTAX. And the devil truly is in the details. And there are many risks to mitigate in implementing a global minimum tax. So complex, it takes 347 pages just to summarize it, and which must be applied in accordance with the commentary and what they call agreed administrative guidance, which is yet to be issued. And this is especially problematic because it's not created in a vacuum. And this is especially important for the US with its 2017 tax reform provisions, such as GILTI, Global Tangible Low Tax Income, BEAT, Base Erosion and Anti-Abuse Tax, and other colorfully named creations to counteract very effective M&E tax avoidance practices. I think in the US, we actually think of catchy acronyms first, and then later figure out what the letters stand for. But the point is that this has to coexist with other national initiatives to deal with the same problem. And it's also important to note that Globe Pillar 2 raises many other unresolved implementation questions. For example, must it be incorporated into domestic law? Does it require changes to bilateral tax treaties? Does it require a multilateral agreement? Can we develop an effective dispute resolution mechanism, such as a peer review process or a global tax court? Is a 15% global minimum tax worth the complexity of Pillar 2? Will this cause a downward global convergence in tax rates, so the minimum tax also becomes the maximum tax? How do we ensure equitable allocation of corporate tax revenue so emerging markets receive their fair share? How can we prevent new tax avoidance techniques to replace old ones? But this is, of course, a work in progress, and we hope for the best. But I strongly recommend that the inclusive framework monitor results carefully from today's baseline and evaluate this endeavor in 5 rather than the planned 7 years. So now, back to the potential impact on tax incentives. I'm looking forward to subsequent papers on the possible effects on tax revenue, foreign investment, vertical equity and taxing rights, and alternatives to tax incentives, so I won't dwell on these topics. Instead, I will be constructively provocative in suggesting that Globe Pillar 2 is actually a blessing in disguise for most lower income countries, which is essentially all of ASEAN except Singapore, and that it might compel them to address the binding constraints to attracting foreign investment rather than continuing to pursue a conceptually flawed and empirically unsuccessful policy of offering generous tax incentives to attract FDI. I laud the policy objectives of tax incentives. No dispute with them. For example, stimulating the economy, creating jobs, increasing competitiveness, helping disadvantaged regions, and so on. But they are seldom the appropriate policy tool to achieve these policy objectives. Instead, tax incentives often needlessly erode tax bases because they are mistargeted and ineffective, create economic inefficiency through distortion of resource allocation, increase the administrative burden on tax authorities, provide opportunities for rent seeking and corruption, all without increasing net investment. Other than that, tax incentives are a wonderful policy. So, although MNEs have never seen a tax incentive they don't like, in multiple IMF and World Bank surveys, MNEs consistently rank many other factors as much more important in attracting foreign investment. For example, political stability, prudential macroeconomic management, quality of hard infrastructure like roads and ports and power and telecommunications, the quality of soft infrastructure, good government, and good governance. The quality of what I call wet infrastructure, your human resources, your human capital, labor productivity, the importance of rule of law and enforceability of contracts, access to input markets, access to markets where you'd like to sell your products. Things like this are much more important than a tax incentive. And the dismal performance of tax incentives for the last 5 decades, is widely understood by fiscal policy decision makers and supporting technocrats. But you have the political economy that makes this much more challenging, because these folks must demonstrate to political leaders that they are taking the initiative. And no action is interpreted as giving low priority to attracting investment. And the easiest way to appear proactive and responsive to political concerns is to promote tax incentives, because they can be enacted quickly and in a highly visible manner. So it's the political imperative that is often driving the creation of tax incentives rather than a sound economic rationale. And the underlying structural problems that make a country unattractive to foreign investors take much longer to address, and the benefits are realized under subsequent administrations. That is, you incur all of the pain now for someone else's future gain. The enactment of tax incentives is also facilitated by dueling power centers with different objectives and metrics for success, often contradictory. For example, Ministry of Planning and Investment or Investment Board is evaluated on investments generated or sometimes just investment pledges. But the Ministry of Finance focuses on the fiscal cost of tax incentives. That is foregone revenue essential to funding crucial public infrastructure and services due to these tax expenditures, which is a fancy way of saying tax breaks. Given the forum here and the host of the forum, I think it's also important to note that Singapore is an exception to this dismal global experience with tax incentives, as it has consistently developed well-designed, carefully targeted incentives in the context that it is already a competitive foreign investment destination, and it is already a low tax jurisdiction that meets the other prerequisites summarized earlier. But Singapore is the only ASEAN country in this category. So to be a little bit more specific, what are the key implications of Globe Pillar 2 for residents and source countries in Asia? For residence countries, the minimum tax does not eliminate the incentive for resident companies to earn low-taxed foreign source income, where the minimum tax rate is significantly lower than the residence country tax rate. For example, if a residence country rate is 32% and the minimum rate is 15%, resident companies still save 17% by investing in the lower tax jurisdiction. But I'd like to focus more on source countries, which includes most lower income countries and most of ASEAN. The minimum tax paid to the residence country increases the tax cost of an MNE's investment in the source country. So the source country becomes a less attractive place to invest for MNEs subject to the minimum tax. But if all investment in all countries is subject to taxation at the minimum rate, then countries will actually have more revenue to fund other expenditure priorities, which is especially important in the aftermath of the COVID pandemic. But more importantly, source countries are limited in using tax incentives to attract foreign investment, known as a tax-bearing issue. But, and here's a key objective of Globe Pillar 2, source countries can in fact raise their tax rates to the minimum rate without any inverse impact on foreign investment. That is, source countries can and should increase their tax rate to 50%, as this would not increase the tax cost for foreign investors. Otherwise, the tax will be collected by the residence countries through the minimum tax. In addition, all countries should adopt a qualifying domestic minimum top-up tax to prevent loss of tax revenue to other countries through the income inclusion rule and the under tax payments rule top-up taxes. So in short, Globe Pillar 2 can be viewed as a blessing in disguise for both residents and source countries, especially since the most ineffective tax incentives are those most easily targeted by Globe Pillar 2, namely reducing the corporate income tax rate, especially via tax holidays. And perhaps this will give policymakers the political cover necessary to resist the temptation of offering counterproductive and self-defeating tax incentives to attract foreign investment, so they can instead devote resources to more effectively increasing their country's international competitiveness. I think I'll stop here about my limit, and I welcome questions from seminar participants. Thank you.
Thanks, Jay. I don't think there's any questions from the floor at the moment, so if you'll allow me, I will kick off with some broad questions about implementation. And I guess the point is really that I'd like to make is you mentioned collective action and the fact that many countries need to act together. What is your opinion on the timelines for implementation of Pillar 2 in particular? I think you mentioned 5 years, 7 years. I missed that, I think. And maybe a discussion around how this could play out in practical terms.
Yeah, collective action, and this is quite different from collective action on trade. We have the World Trade Organization, we have an international governance body, and we have multilateral trade treaties and trade groupings. We don't have a WTO for taxes. We don't have a global tax court. We don't have many multilateral tax agreements. They're very difficult to do. Tax treaties are very, very complicated, labor intensive, and they take your best people. So I think the timeline is very optimistic and probably not realistic. They talked about starting to implement it next month, 2023, I believe. It's not going to happen. If you don't have the administrative guidance, and that's really the core. You have in a country, you'll have a tax law, very broad, enabling, it's an umbrella. Then you have a bunch of decrees, usually from the Minister of Finance, Then you've got your tax authority that issues the regulations. And the regulations take a long time. Often you have a public airing or public review process. You get the stakeholders involved and it goes up and down. And that hasn't started yet, my understanding. And you know, it's very ambitious. I was looking at the rules and, you know, on the surface, they sound very simple. You know, effective tax rate versus the minimum tax, and you pay the difference. Except, you know, every variable has pages and pages and pages of definitions and formulas. It's something that tax lawyers thrive on. And so to do this, and you're right, the word collective action, because this is, I think, a global public good, but we don't have global governance structures to manage it. So it's a bit of an institutional vacuum, bit of a legal vacuum, and you do have all these tax treaties in existence. So when I raised the questions about what will countries have to do according to their own laws, what are their requirements? In the US, does it have to go through Congress, not through Congress? What is the authority of the executive versus the legislature? And, you know, and what is the status of all of the other negotiated agreements? And that is, you know, we talk about 141 countries that have signed on, including the US. And without being too pessimistic, a lot of the unilateral actions, for example, the US, have exactly the same objective. You know, the idea is that we want to go from fear of double taxation, now it's double non-taxation. And we want, you know, we want those with the capacity to pay, the MNEs, to pay taxes somewhere. And you figure out how much and how to allocate it. So on the surface, I think we're all on the same page, heading in the same direction, but how in the world do you do this? And with taxes, you're also dealing with issues of national sovereignty. Very, very sensitive in almost every country. So I would say that whatever the timetable is, just as BEPS was delayed and took a lot longer than people had expected, to work out the details so that you could actually implement it in an equitable, transparent way, so that everybody understands it, everybody can play by the same rules, and you have to have some type of enforcement mechanism or dispute resolution mechanism, or it doesn't work. And, you know, everything then falls apart. So it's in a sense, very ambitious, very noble, very necessary, and very, very difficult to do in practice. That's why I had all the lists of the implementation issues. And they're open questions. I don't have answers to these, and they will vary. You mentioned that Asia's voice has not been heard very much. And I think, you know, ASEAN is different than the EU, for example. You know, it's different than the OECD with some overlap. And they've got the G20, and you've got, you know, places like Indonesia, part of the G20. And so you've got overlapping groups, overlapping jurisdictions. But I think your question is spot on. It's the implementation details, implementation timeline, and I think we have time. The one thing I'm absolutely certain is that all of our wonderful tax planners, tax lawyers attending the seminar, you will do very well, because it is so confusing, it's so complex, that your services will be in very high demand. That's the one thing I will guarantee. Whatever happens to this, your services will be in great demand.
Indeed. Okay, so we've got a couple of questions that I think I should pose to you from the floor. The first one is about the interaction of the US foreign tax credit system and Pillar 2. You know, I guess you know, whatever happens in the US will affect how quickly whether we are able to implement around the world. So yeah, if you could answer that question first. I think the second question is also similar. So maybe if you could treat those two questions posed together. Yeah,
I mean, that's a great question that I was hoping nobody would ask. But And it's a huge question. It's the largest economy in the world. And I mean, the good news is that in principle, the U.S. has an agreement. They've signed on to this. They're one of the 141 countries. And they just passed domestically in the Inflation Reduction Act, a minimum corporate tax in the US, a little bit similar to our alternative minimum tax for the personal income tax. So in principle, there's a lot of support for this. And in the rules, there's some reference to this will be done in accordance with coexisting with guilty, for example, which has the same purpose. So the rates are the same. You look at the 15%, you look at, trying to get these intangibles, trying to deal with a digital global economy, and the platform businesses and all of that. But what's good about Pillar 2 is that it's not just digital. So you're trying to have equal treatment of different types of businesses, whether they're digital or more conventional, which again makes it easier to apply past principles for consistency. But the short answer, I must say, nobody really knows. They have to coexist. And there's, the US is guilty of exceptionalism, right? We're different. And those who speak Malaysian, Indonesian, lain daripada yang lain, right? We're different. But the objective's the same. The numbers are very similar. The approaches are quite similar. And at least now, the Biden administration and Secretary Yellen are fully supportive of this. Breaking news, the results of the Georgia election were just announced, and the Democrats now have an additional seat in the Senate rather than losing the Senate. Why is that important? It's the Senate that does treaties. So if that is involved, it doesn't involve the House of Representatives, it's a Senate. So, people were worried about continuity of US policy. We've been very inconsistent, but I think in this case, we've signed on, we're part of the G20, part of the group that's supposed to implement this. But the details, I mean, there was a more specific question. How exactly does this work together? How do they coexist? Don't know. And I've asked a lot of tax lawyers, and they say they don't know, they're working on it. That's a great question. I'm sorry, I can't give you a more definitive answer.
Yeah, so I guess that's all going to play out in the
Yes.
next couple of years, maybe as soon as possible. Again, all of the tax lawyers and practitioners have a role to play. But again, there is diversity across the world, Jay. Maybe if I can prevail on you to maybe comment on this within the context of Asia. How do we build a consensus within Asia, right? Even with one region, albeit quite diverse, how do we build that consensus to or a common platform by which we can air some of these issues of collective action that we talked about earlier? How could we do that? In your experience, how could we do that?
Well, the first thing I would say, although ASEAN is diverse, except for Singapore, all of the revenue projections, we'll probably hear more about this later, the revenue impact for most of ASEAN rounds down to zero. I mean, it's negligible, and they should not be putting a lot of resources into this. That's my advice to them. That's not where the money is. That's not their tax base. Singapore is different for all sorts of reasons that Singaporeans know best. But other than Singapore, I think it would be relatively easy to build a consensus because it doesn't have, I think, tremendous revenue implications, and it might help to prevent destructive competition among ASEAN countries. For example, everybody's competing to be the China +1 for foreign investment as multinationals try to diversify. And there's a lot of competition, it's healthy, but at least they don't have to give away things that are unnecessary, like the tax breaks, and can compete on other elements and kind of use those scarce resources for domestic priorities. So in a sense, it could be a win-win where there's still going to be a lot of competition, but it could be more constructive than destructive competition. I'm leaving Singapore out because its stake is different, and I think the revenue implications could be greater for Singapore.
Thanks, Jay. Okay, so I think we've come to the end of our time with you, Jay. I hope you can stay, but appreciate it's very late in the evening for you. I'm certain all the participants today will join me in expressing our gratitude and thanks for making this keynote speech and sharing your thoughts with us in today's seminar. We'll wish you a good night. Look forward to seeing you whenever you're next in the region. Thank you so much.
Thank you for the opportunity.